Go ahead and call this meeting to order of the Maricopa County Board of Adjustment. Rosalie, if you'd please go ahead with a call for roll.
Chairman Loper,
Present.
Vice Chairperson, Member Carden, Member Clapp.
Here.
Member Ward.
Present.
Chairman, we have a quorum.
Thank you very much. I'll go ahead and make the announcements. This meeting has been noticed in accordance with the open meeting law of ARS 38-431. Agendas are available within 24 hours of each meeting in the Maricopa County Planning and Development Office and are also available on the Planning and Development website 1 week prior to the hearing at www.maricopa.gov/planning. With respect to the hearing process, cases will be considered in the order they appear on the agenda unless otherwise agreed to by the board. For each case, the applicant will be given a set amount of time to present their testimony. Any witness wishing to give testimony in a particular case shall notify the board of such interest. This shall be done by filling out a speaker's card if you're here in person. That looks like this. Those will go to Rosalie or to Rachel up here, or registering a desire to comment as noted on the published agenda if you're doing this online. Also, at the appropriate time for each case, the chair will ask those attending in person and online who wish to speak to a case to raise their hand by clicking on that icon on the webinar screen. Staff will provide the chair with the names of persons who have registered and noted a desire to comment, and those registered participants who have raised their hand. The chair will call on each named participant one at a time. Such testimony shall be limited to a maximum of 3 minutes. However, the actual amount of time allowed for such testimony shall be at the discretion of the board chair. The chair will conduct the hybrid in-person and virtual public hearing according to the bylaws and according to the rules established by the chair regarding public comment. Votes will be done by roll call vote only, and the chair will identify the specific members responsible for all motions and seconds. With that, we'll move on to the minutes. Those in attendance on the board had a chance to review the minutes from June 19th. And are there any comments or corrections? Seeing none, those are considered to be approved. We'll move on to the agenda. First item is code compliance review, V2500307. Mr. Charles Hart.
Good morning, Chairman Loper, members of the board. This is an appeal of a hearing officer's order of judgment for case V2500307. And this is for the property at 7628 East Mawson Road in the Mesa area. This case came to us back in February of this year. We'd received a citizen complaint of construction without permits and subdividing a single family residence into 3 separate living areas and also junk trash debris. We conducted an investigation and found on March 7th, 2025 that the alleged violations were in fact occurring, other than we couldn't verify the junk trash debris issues. Research of county records found no active permits for the site, and we issued a notice of order to comply on March 19th of this year, and then a stop work order was placed by building safety staff on March 21st of this year. Staff continued to receive complaints, and a follow-up inspection was conducted by the building safety staff on April 11th, and they noticed there was still work continuing on the single-family residence. Code compliance staff researched the site again on April 17th of this year, found again no building permits had been applied for, so an administrative hearing was scheduled for May 20th of this year. The summons was prepared and mailed via USPS certified mail to the respondent, and the site was posted on April 18th of this year. And the posting inspection found no change in the condition of the property, and the site remained in violation. The case was heard by the hearing officer on May 20th of this year. The respondent appeared at the hearing through a representative. The hearing officer found a respondent responsible for the violations listed above, and he was ordered to pay a $10,000 non-compliance fine and then a daily non-compliance fine of $1,000. The daily fine was only to accrue if there was continued construction that was verified. So on June 9th this year, the respondent appealed this decision to the Board of Adjustment, and we are here today. So at this point, staff would recommend to uphold the hearing officer's decision. The site was properly posted, the notice was properly sent, and the respondent did appear at the hearing through a representative. Be happy to answer any questions you may have at this time.
Thank you very much, Chip. And just to clarify, our role is not to redecide the case, the merits of the case. Our role is simply to review the process and decide, was there a flaw in the process, the steps taken into it? We can't argue the merits of it. That's not what we can do. Is that correct?
Chairman Loper, members of the board, that is correct. This is simply to determine whether there was an error or a procedural issue
All right,
during the
thank
process.
you. Thank you very much. Member Ward, do you have any questions of Mr. Hart at this time? Okay, and I know we're having a couple of technical difficulties. Hold on a moment, everybody, so we get Member Clapp reconnected. Oh, Member Ward, did you have a question?
No, I was just going to respond. I do not. Thank you.
Okay, thank you. And then Chip, I do have another follow-up one for you, or Mr. Hart. So when February, since February, really nothing has changed. You've reinvestigated, went to the hearing officer, but they have done nothing to correct it since this was first heard by us and then continued. That's correct?
Chairman Loper, members of the board, no, they have obtained a permit since then.
They have?
They are, yes, they have obtained a permit and they are currently working on correcting the issues there at the residence.
Okay, so they are working to correct it.
Yes, that's correct.
All right, thank you for clarifying that.
This is Max Carpinelli, Deputy County Attorney. May I chime in on the standard of appeal here?
Absolutely. Go ahead, Max.
The zoning ordinance, specifically at 1504.3.10 review of hearing, this board has two things that it can do. Is first, either affirm the action of the hearing officer, or second, decide that some procedural error existed and remand for further proceedings. So Chip was correct. I just wanted to point out that there are two options here. Either you affirm it, that everything procedurally was fine, or if there was an issue, remand it for further proceedings before the hearing officer.
Thank you, Max. And I guess there is a third option, which we've exercised before. If for some reason we could always continue this again, if need be, if we wanted to give additional time for something too, correct? We could continue at another time, an additional time?
I assume with, stipulation of the parties, maybe. That's an interesting.
Okay, just throwing that out there.
Chairman, we have lost contact with Member Clapp. I'm trying to call.
Okay. And Max, when that's happened prior, when we've lost a commission or a board member, your predecessor, Wayne, he held the opinion that if we started with a quorum, but we lost somebody due to a technical difficulty, because we started with a quorum, that still held true as long as the existing remaining members voted the same way on a given item. Do you continue with that? Or is that your opinion still, or do we have to withhold doing anything till we can get Member Clapp on?
I don't think you could hear the item without a quorum, but if you lost a quorum for whatever reason, you wouldn't be able to vote as a body without a quorum.
I'm on the
Okay.
line now. Can you hear me?
Oh, she on?
Yeah, I heard it.
Yeah, I have, for whatever reason, you've sent me a link to join as an attendee to the meeting, so I can hear you now. I could not hear Darren's phone at all.
Fantastic. That's great. We don't see you, but we can hear you loud and clear. So
Yeah,
great.
and
That's
I
great.
heard the case presented and then I was cut off, so you can start from there.
Fantastic. All right. Do you have any questions of Mr. Hart?
My only question is when did the actual work end? Because it sounds like you've found that in April the work was continuing.
Chairman Loper, Member Ward, I'm not sure the exact date that the work ceased on site. We'd had continued complaints from the neighbors. Some of that may have just simply been trips back and forth to the site with no work occurring, but our building safety staff had verified that there was work occurring as late as April 11th.
Okay, all right, thank you. That was my only question.
Any other questions by Board Member Clapp or Board Member Ward? All right, seeing none, I'm going to go ahead and open the public hearing. The the applicant or applicant representative, and I do have a card for Tom Walcott. If you could come up to the podium and then just provide your name for the record, please. Into the microphone.
Good morning. Thank you for taking the time to meet with us today. I am Tom Walcott. I'm an attorney at Provident Law, and I am here on behalf of my client, ACKB Properties LLC, the title owner of the at-issue property. Before I go further with this, I'd like to just question the panel, thank you, about the third option you discussed. And if Max is still on the line, then maybe he can tell us. We're wondering about the possibility of stipulating to continue to hear this and in the meantime, allow us to submit a written briefing to the panel for consideration.
Mr. Walcott, I'm one of three, but at this point, that's premature. Typically, that's done at the board's request as we discuss an item, not at an applicant's request. You would need to give us a reason to continue it. So far, I've not heard any reason for that.
Well, thank you. Notwithstanding the admonition in Max and Mr. Hart's admonitions about hearing new facts or evidence, you asked whether a permit had been issued, and the startled look on your face seemed to say that it mattered to you. Also, in addition, the two questions we did have from the remote applicants were regarding the factual bases for some of the conditions and what's happened on the property. So it appears to be germane to consideration what we're doing here today. If we need a procedural defect, I would point you to 1504.3.5 that requires at the initial hearing that we had sworn testimony of all witnesses. And if you go back and listen to that audio recording, the hearing officer did not swear any of the homeowner witnesses that were ganging up on my client from 7:18 in the recording on, of which there was about 15 or 18 minutes of rock throwing and name calling. And that I believe impacted the hearing officer's determination as to the fine amount and actually finding a violation at all, especially of the zoning ordinance. So that is a procedural defect in that it appears there was consideration of unsworn testimony. And I know the rules of evidence don't technically apply here in these proceedings, but your rule says it has to be sworn to come in. And that did not happen at that hearing. I invite you to go back and listen to it and confirm what I'm sharing with the panel here today on that. Why we are here is, if you'd like me to go on, is
Sure.
to get to a just outcome of this matter, bearing in mind the code compliance mission statement of gaining voluntary compliance with codes and regulations from the property owners. I looked at the findings made by the hearing officer, and what is not in there, and what was devoid from code enforcement's file is the numerous telephone calls, emails, and proposed compliance agreements my client sent to the department in response to their invitation in the notice of violation that says, if you need more time or information on how to cure these problems, contact us. He did that repeatedly, and that's not in their file. It didn't show up with that information they produced about the good faith efforts of my client, who was ignorant, not an excuse, but he was truly ignorant of some of these requirements. Once they got on his radar through nefarious means or otherwise, he has made every effort to move forward, gain the permit, which he did, as well as work cooperatively with SRP to his great expense, which wanted him to move his power supply box from the back of the house to the side of the house at a $10,000 cost, and on and on. He's got his dust permits. He's done everything he can. The only reason we're here is because there was a targeted conspiracy of neighbors that kept calling the sheriff's office, kept trespassing on his property to take pictures, kept contacting. Over 300 pages of emails were produced from your office as a result of the contacts from those folks. And what we don't have in the findings is a specific zoning violation. Plans that were submitted are single family. That's consistent with the zoning for this property. The construction on site, there's been no photographs or any evidence presented that it's not consistent with single-family construction or exceeds number of bedrooms, of which there is no limit, or otherwise violates the fire code. So that I'm asking for information, supplemental information, bases, and ultimately the plea is to either waive the fine now that he's in compliance and in good faith, or reduce the fine accordingly so as not to maintain the manifest amount. I also have a question. I'd like information on how the $10,000 amount was determined. There's no per day fine times X amount of days. It just appears to have been plucked out of the air by the hearing officer. Your rules also say maximum fine per day or per violation is the cap on a misdemeanor 2, which is $750. So how we got a $10,000 flat fee fine for non-compliance, maybe there's a separate rule out there that I'm unaware of. That's possible. I don't do a whole lot of this work, but I'm just asking if it's out there. I'd like to see it. Other than that, it seems unrelated to the actual violation itself. So I'm asking to consider the following items with regard to this property, the history of the property, and what my client has done out there on it. Like I said, currently he has his permit, and he has his dust control permit for the groundwork that he's caused to be done out there as well. Excuse me for a moment. There's one more document I wanted to review here.
While you're looking for that, I do want to clarify to Chip or Darren. Has a permit been issued or has it just been submitted for?
Chairman Loper, members of the board, the permit's been issued.
Okay,
June 25th, Mr. Loper.
okay, thank you.
And there has been a subsequent inspection of the property that found no violations and an invitation from another neighbor, not surprising, that he was also in violation of this, that, or the other. An ADEQ came out and found no violation as well. The sheriffs have also grown frustrated with the frequency with which they're being asked to visit this property. So I would ask, based on the voluntary compliance and the remediation and the gaining of the permit that my client has done, that's one of the considerations I would ask the panel to consider. The early pre-hearing in response to the invitation and the violation notice to contact them, ask for more time and or information, which was done through the submittal of a proposed compliance agreement, as well as follow-up phone calls and emails that went unresponded to until 2 days before the initial hearing. Like I said, he's ignorant of this law, but it was unintentional oversight. It's not an excuse, we know that, but a $10,000 fine seems disproportionate to what the timeline and the actual events on this property show. The alleged violation that may or may not have existed, building without a permit, did not create a risk to public safety. It was not a structural issue or an environmental issue. And he also has no prior record of any kind of building code, flouting the building code or the regulations. So again, I just ask, in keeping with the goal of the Code Compliance Division to achieve voluntary compliance from property owners, that has in fact been accomplished here. And on the maintenance of a fine at the level it's been set, whether it's rule compliant or not, is punitive and not corrective. And with that, I wrap up my comments. Thank you.
Thank you very much. Before I say anything, I'm going to ask Member Ward or Member Clapp, do you have any questions of the applicant, the applicant's representative at this time?
I do not.
None from Member Ward. Member Clapp?
The permit was approved on July 25th, correct?
June 25th.
I'm sorry.
June 20, when was it submitted for permit?
Chip, do you know the day it was submitted?
Chairman Loper, I do not.
Chip does,
I may have that, Mr. Loper, in my timeline. I'm not sure, but I think I may.
but keep in mind, Member Clapp, that that's the submittal date. There's also a review period within the county, and there's probably, a couple of review, go back to the architect, engineer, that, kind of a back and forth.
Mr. Chairman?
Yes,
Yeah,
I-
I understand my only question was the case was heard on May 20th. So I'm assuming the permit was applied for after that hearing. We only know it was approved on June the 25th.
Right. Darren, go ahead.
And before compliance is actually verified, the permit has to be completed.
Okay.
Yeah. Okay, thank you.
Mr.
That's all my questions.
Okay, Mr. Walcott, did you have a date?
Again,
And that
I have the permit issue date is June 25th. I'm trying to see where it was an application.
if you have a receipt, that would have it on it when it'd give you the permit number and it'd have a date.
Yeah.
If you don't, you don't, but that's okay. I believe, and I'm going to ask Chip and Max to jump in here, slap my hand or to tell me if I'm incorrect. The only thing that is our purview in all that you ask for that I believe that we could take a look at would be anything that was procedural. The only thing I caught out of everything that you gave us, it's a great presentation, but would be the discussion about some of the testimony that the folks weren't sworn in. Would I be correct that that's maybe a procedural item or not? Chip, Max, any opinion on that? Darren?
Chairman, go ahead.
Oh, I was going to say, I think Max is ready to opine. I would say the hearing officer tends to swear the entire group in at the beginning of the hearing, not individually.
That's what I recall, but I hate to say that I've been in front of him, but.
This is Max Carpinelli. Yeah, that's my recollection too. They kind of do a mass swearing in, and without listening to the audio, it's hard to say. But that, I guess the board here could consider whether there was sufficient testimony in that regard, and to that effect, there was mention of the neighbors not having gotten sworn in, but there's also other evidence presented by, the court enforcement officer, other witnesses that may or may not have been there. So that may be one component that this board could consider.
Okay. And then Chip, Darren, in the past, it's not for us to consider, but it's kind of a help to the applicant. He mentioned about at the end of the day, the ultimate fees, the fines, how the process goes. My recollection, not for us to decide, is that there's sometimes has been, if they proceed as they should through the permitting process, they ultimately get it, they get the clearance or the C of O for it. Could you talk a little bit about is there any flexibility, not to be decided today, but just to let the applicant know kind of what the outcome could be should they proceed as they're supposed to?
And Chairman
And
Loper.
it's in your supposition, I recognize, but.
Chairman Loper, in proceeding with the permit and getting
Right.
that completed is what you're saying. So yeah, so once the permit is finalized at that point, it would still, we couldn't final it until the fines are paid technically. And just to go back to what the representative was saying here was that actually it's a class 2 misdemeanor, but it says this is an LLC. The maximum fine is $10,000. So that's where it differs from an individual, which would be $750. Just to clarify that, to go back to that statement, that's where the fines come from. So, the hearing officer chose that as being the penalty because he could go up to that amount.
Because it's a business,
Because
not
it's
a
an
person.
LLC. Yeah, the ownership was under an LLC. So that's where that comes from. Just to get back to that. Also, Rachel gave me the date. The submittal date was 5/8/25 on the building permit.
May 8th. So it was prior to going to the hearing
Correct.
officer. Okay.
Correct.
All right. Member Clapp, did you catch that?
I'd say that last part again. What happened before the hearing? I didn't catch it.
The permit was applied for on May 8th. The hearing officer was May 20th. So they did apply
Okay.
for it prior to going to the hearing officer.
Okay.
So the hearing officer
Okay.
presumably had that information.
Okay.
All right. Mr. Walcott, if you go ahead and I don't think we have any questions for you right now. We may. Let's see if there's anybody else that wants to speak on this. So go ahead. Is there anything else you wanted to say right at this time?
I wanted to thank you and the panel for their time. Mr. Hart, thank you for clarifying the LLC. I think that was you that did that. I stole my thunder. I did also find the May 8th permit application date. And just to touch base with what Max was saying, I'm not contentious in the sense of fighting over everything. I agree. Usual, it's very common. The hearing officer has everybody that may or may not speak, desire to speak or otherwise raise their hand to get sworn. That is common, even usual procedure that I've seen. I know the audio recording, that is not what happened here. So I just, as a point, I know someone better doing their due diligence, go back and listen to that audio recording and see if what I'm saying is in fact true. But, and I appreciate I think what you were driving at is, and I don't think you had an answer to your question. I don't think that you can give one today, and I'm not asking for one, is it did sound like possible if they stay on course, everything is done, final permit, and I know we have that hitch of the can't be finalized until the fines are paid, but certainly they can shape some sort of remedy for a tax-paying citizen to get around that with an exception of some kind. But that possibly it could be reconsidered for reduction or possible waiver at a future point. Want to see if all is issued and full compliance is in fact confirmed. That's what I heard you say. I might be optimistic, but I thought you would get driving at. But that's it. I don't have anything more to share with you this morning. Thank you all.
All right, thank you. We may ask you some questions as it goes on. Thank you again. This is a public hearing. Is there anyone else in the audience who wishes to speak on this case? All right, seeing none, is there anyone online?
Nobody online indicating they wish to speak.
All right, thank you very much. I'm going to go ahead and close the public hearing and turn it over to the board members for discussion and or a motion. This is in District 2. Member Clapp, I believe that's your district.
Yes.
So if you want to lead with the motion or just discuss it, or if you're not comfortable.
Well, I go ahead. Go ahead.
No,
You
no,
can
go
speak.
ahead.
The fact that the permit was applied for before the hearing, I think, is relevant and was not in the information that we received, because in reading the materials that I received, it would seem that the obvious answer would be that I would uphold the hearing officer's order of judgment. Do we have any other option for deciding this? Is it yes or no, we do uphold it or we don't uphold it? You know, if we uphold the order of judgment, does that leave any discussion that goes back between staff and the applicant on what they're going to ultimately have to pay in order to get their permit approved?
Member Clapp, all I can tell you, and Chip, Darren, jump in here, or anyone else, including Max. All I can tell you is that historically, we hear about a half dozen of these a year.
Right.
Is that historically we've upheld staff's interpretation or the procedural interpretation, and that they have almost always, at least to the best of my knowledge, worked with the person who the violation's been with, and it's had a reasonably good resolution. That's what I'm aware of. I mean, I don't know the particulars of that, but that's what I'm aware of. In this case, I don't know if there's any opportunity to reduce it because it's an LLC versus a
Right.
person. Routinely, we usually get people, and I think the board looks at that differently. Frankly, I didn't know that there's a difference between an LLC and a person or an individual in terms of fines. After Max made the clarification about how they do the swearing in my own recollection, although it's been a few years, that to me potentially could have been a procedural issue, potentially, but that's no longer a procedural issue in my mind. So
Right.
I don't see a procedural issue. So to me, yeah, it's those two options, or it be continued so we get more information. I don't, as I say here, for me, see that there's any additional information that could be
Yeah.
provided.
I would agree with that. My feeling about this case is that I will make a motion to uphold the hearing officer's order of judgment on this case. And then it's up to the staff to work with the applicant on how they're going to proceed from here.
So we have a motion to uphold the hearing officer's order of judgment by member Clapp. Do we have a second? We have a second by member Ward. Rosalie, if you please take roll call vote.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion to affirm the hearing officer's judgment by a vote of 3-0.
And to the applicant, I hope you understand what our parameters were and what we could and couldn't do. And again, I would tell you that my personal experience and my experience as being on the board is that this isn't staff trying to make payroll. They've always worked with property owners to try to, their issue is trying to uphold the safety, welfare of people with getting building permits. They're not trying to do this to be argumentative or petty or anything like that. I think you'll find that they'll work with you on this. So I would hope that would be the resolution.
Mr. Chairman, just for the record, a decision of the Board of Adjustment is appealable to the Superior Court.
Did you catch that?
I do, I'm aware of that.
Okay. All right, we'll move on. Thank you very much again. Move on to regular agenda. Item number 2, BA 250002, the Thompson property in District 2. Joe? Or who's doing this for Joe? You are, Ron?
Joseph is no longer with the county, so I'll step in.
Where'd he go? Did he go somewhere?
Yeah. he
Can
took
you say?
another look at-
What? Buckeye. Oh, maybe I'll see him.
So this is an application that came before the Board of Adjustment at the last hearing, June 19. It's coming back to you for your reconsideration. No decision was made at the previous Board of Adjustment meeting. Rather, a decision was made to continue this to give the applicant a little bit more time to consider possible other options for locating the building. The applicant is proposing new construction in a portion of the rear yard for a detached accessory structure of approximately 7,200 square feet. It is proposed in the required 25-foot rear yard along the west side of the property. Although accessory structures may be located in the rear yard, they may not cover more than 30% of that rear yard. In this case, the rear yard is measured as approximately 3,750 square feet in area. The building that is requested is proposed 5 feet from the property line, from the west property line, which is the rear, and would include 2,400 square feet inside the rear yard, or 64%. Rather than the maximum 30%. Staff reviewed this application, did not identify any particular condition or hardship that would inhibit reasonable use of the land. However, if the board finds that the applicant has met the statutory test and states it in its finding of record, approval of this variance would memorialize the maximum coverage of 64% of the rear yard rather than the 30% for APN 220-65003U. And that concludes the presentation unless you have any questions.
Thank you, Ron. I believe that's your first presentation that I've heard. Did a great job. Are there any questions of Ron at this time by any of the board members? Member Clapp?
Nothing at the moment.
Okay, I do. If you could go back to the exhibit where it was kind of the site plan, had the red, this one, yes. So Ron or others, so aside from reducing the size of the building, are there other remedies such as moving it within the building? Is it that it's encroaching?
It's located 5 feet from the property line.
If it was within the setback or outside of the setback, would it be okay?
Yeah, if it's outside, definitely, but he can move it back 16 feet. We've determined this from the previous meeting. He can move it back 16 feet and have less than 30% of the building in the rear yard. Anything closer than 16 feet would require variance.
So it's in the rear yard period. It's not necessarily
Well, it's it's more than 30% that's in the rear yard.
in the rear yard. Okay. All right, that was my only question. Seeing no other questions, go ahead and open the public hearing. Is the applicant, Mr. Thompson, or other representative in attendance today and wishing to speak? Seeing no hands and having no speaker card, Nadia or David, do we have anybody online?
I'm not seeing anybody with a hand raised online unless, David, you've talked to somebody.
Chairman, there's no one online.
All right, well, it's in our bylaws that these be continued. And I
This has
provide-
already been continued.
That is true.
I believe.
We heard this last month.
That's right. I was out last month, but you are correct.
Now, the applicant wasn't intending to be here. I'm not sure what the problem was.
I'll go ahead and move this to the end of the agenda. Maybe they'll show up. We don't have to take a motion to do that, correct? We'll just move it. All right, move that item to the end of the agenda. Move on to item number 3, BA 250015, the Urshan variance. I probably screwed that up. This was also continued from June 19th. It's in District 1. Paula?
Thank you, Chairman and members of the board. Agenda item number 3, case BA 250015 is a continuance from June 19th BOA hearing. The applicant is requesting 2 variances in the Rural 43 zoning district for parcel 304-88077S. The property is comprised of approximately 16,336 square feet with a lot width of 105 feet, and it is part of the Chandler Heights Citrus District. The Chandler Heights Citrus District was rezoned from R4 to R130 and R4 and R135 to Rural 43 RUPD by government action under case C 2005-006. The RU43 zoning district requires lots to have a minimum lot area of 1 acre, but many of the lots within the district were created less than 1 acre prior to the RU43 zoning district. The small lots were impacted by greater setback imposed with rural zoning districts with small buildable areas. The rezone with overlay deviated the required setbacks to allow a larger buildable area with a front yard setback requirement of 20 feet, rear yard setback of 25 feet, and side yard setback of 10 feet. Case LU 2022-0067 was approved in November of 2022 for a legal non-conforming lot area of 16,336 square feet and the lot area of 105 feet. The applicant is requesting a variance for the front yard and the rear yard setbacks to provide a large buildable area within the small lot. The variance request is to allow a 10-foot front and rear yard setback. The applicant recognizes there's no peculiar condition facing the property, but would like to develop the property in the future with a single-family residence. At this time, I am happy to answer any questions. Thank you.
Thank you, Paula. Great presentation. Are there any questions at this time? Paula, Member Ward? Member Clapp? I have none at this time. Thank you again. Go ahead and open the public hearing. Is Mr. Urshan or a representative in attendance? Batting 1,000 here. Do we have anybody online? Do we're aware of Nadia or David?
Again, nobody online with their hand raised or indicating they'd wish to speak unless.
We have a bunch of people in the audience. No one here for BA 250015. The property in Queen Creek at Happy Road and 181st Place. Urshan, E-R-S-C-H-E-N. Okay, move that to the end of the agenda after the preceding one. All right, is there any interest in taking it to action? Because I actually have some thoughts on this one. And we'll put them both at the end of the agenda for now. Move on item number 4, BA 250017, the Amateur property in District 3. Guess this goes to you, Ron.
Yes. Thank you, Mr. Chair. This is an application for new construction, new residential, single-family construction, and it's under an active building permit. The site on which this construction is proposed includes steep hillside slopes on the southern edge or end of the property. The zoning ordinance prohibits disturbance of the hillside area. For your information, the hillside area is defined as a lot, tract, or parcel having a natural slope of 15% or greater within any horizontal distance with a 10-foot elevation. The orientation of the proposed construction, although it meets the building setbacks, it does not avoid disturbing some of the hillside area. According to the submitted application, the disturbance would encompass 1,162 square feet of cut for the building pad. After reviewing this application, staff determined that new construction could be accomplished on the building site, similar to other properties in the area, and avoid the hillside slopes just by reorienting or redesigning the building. As such, staff has not identified a condition or hardship that would inhibit the reasonable use of the land. However, if the board finds the applicant has met statutory test and states it in the record, approval of this variance would memorialize 1,162 square feet of disturbance for APN 211-24105F. And that concludes my presentation, unless you have any questions.
Thank you. Again, another great presentation. Are there any questions, Mr. Quarles, at this time by any of the board members? Fern? Member Clapp? I do have one. You'd mentioned maybe a reconfiguration or is it a reconfiguration of the home as proposed, or is it a reorientation?
It's mainly a reorientation to take it out of the building or the disturbance.
Have you had any discussions with the applicant on it? I know you probably just got this case.
Yeah, I have not. Joseph probably has. I know the applicant is here to discuss that.
Okay. All right. I'll go ahead and open the public hearing and ask if the applicant, which is identified on this as Chris Krieger, is in attendance, or anybody for this one?
Chairman, I have Chris indicated, Chris, I have you unmuted, but he indicated that George was going to speak on his behalf. I have George unmuted also. George never responded to my text, but George is unmuted. I assume he's also online.
And we also, it looks like, have somebody in the audience. Did you want to?
There you go. That's even better.
I'll take the person in the audience first. If
Perfect.
you could just provide your name, speak into the mic. You can, there's a button to raise that too, somewhere.
This should work. Can you hear me okay, Mr. Chairman?
Yes,
My
go
name
ahead.
is Clint Amator. I'm the owner of the property. I really don't have a whole lot of preparation to speak on this. I can answer questions, I guess, but Chris, our architect on the line, sounds like we're missing a person.
You're
So
probably paying some consultant. You might as well get your money's worth, right?
you bet.
You hold tight. We might have some questions just for you.
Yes, sir.
All right, we'll go ahead with whoever wishes to speak online. Nadia, David.
So, yeah, go ahead, George. I assume you're the right person. No one ever told me other than your name was George, but you are
Hi,
unmuted.
yes, hi, this is George Malouf. I am the civil engineer on this job. Hopefully you can hear me clearly. Please let me know if you can hear me.
We hear you, but not that clearly.
Okay, probably because the internet connection is not that good. So regarding the orientation of the building, it was never discussed as to how to orient the building itself. We tried to minimize the hillside disturbance as much as possible, and that's the best we can we can do to fit the house. Now, to me, the house orientation is matching the neighboring properties. If you want to rotate the house otherwise, I think, to my opinion, it's going to look awkward in the neighborhood. Every house is facing one way and our house is going to be facing the other way. And again, we never discussed the issue of reorienting the house. Now, what we did everything we can do to minimize the disturbance. Like we shortened the driveway. We positioned the house in a way to shorten the driveway and to meet with the some of the requirements that impose shortening the driveway as much as possible. Also, we cannot push the house anywhere north because of the existing wash. So basically, the building envelope is limited between the hillside area, the north wash, and you can find all the problems in this small property. And again, we try to do our best to be able to provide Mr. Amateur his residence. I don't know if there is anything I can add to convince you that we did our best. I don't know if you have any other question. I can list the variants that we submitted, but I don't know if it's relevant at this point.
All right, does that finish up your presentation?
Yes.
And in your last name, George?
Malouf.
Okay.
Maalouf.
Nadia, can you can capture that from the screen? Okay. And it sounds like internally you went through some options. The property owner, Mr. Amateur, is nodding his head yes. Okay. Does Chris wish to speak as well?
Go ahead, Chris.
Can you hear me? Yeah, Hector is the designer. He's with Platinum Designer as well, and he was unable to, he said he's muted, so he couldn't say anything. But he did want to mention too that if we reorientated the house, we would be losing most of the views that the amateurs were trying to gain by having the house orientated in this direction. So that was the main reason for having the house placed where it was. And Clint can probably also confirm that. That was all I had right now.
And you are Chris Krieger?
Yes.
All right. Thank you. Any questions of Chris or any of the speakers by any of the board members? Seeing a nod no from Fern. Member Clapp, any questions?
No, thank you.
Okay. All right. Well, all three of you hold tight. We may have something. Is there anyone in the audience who wishes to speak on this item? Do we have anyone else online?
No one else online.
No one else online. All right, I'm gonna go ahead and close the public hearing. This is in District 3. We don't have a representative from District 3 here in attendance. I'll give you my opinion on it and open it up for a motion and for discussion and or a motion. Looking at the site plan, there are a number of constraints with it. I imagine you could play, there's probably a lot of different options with this. I'm of the opinion myself, having worked on hillside properties, beauty's in the eye of the beholder. I don't know if you gain a significant amount by tweaking it one way or the other. What's the lot size on this, Mr. Quarles? Do you know off the top of your head? Or if anybody, any of the speakers? In any event, the percentage that they're going over, the 1162, I don't know if there's an orientation looking at this that isn't going to have something that impacts the hillside disturbance, because there are no, other than reducing the size of the home, I would imagine that given the cost of this lot and the constraints with it, that would be a pretty significant redesign. So I'm not opposed to the variance request myself. I'll just throw that out there. Any other discussion by any of the board members and or a motion?
Chair Loper.
Member Ward.
I'm sorry.
I agree with you, and I would be willing to make the motion to proceed. Let me just see where the language is. Or if you want to make the motion, then I'd be happy to second it.
Go ahead, Member Ward.
You put me on the spot. Okay. I move that we approve variance agenda number BA 250002 with the
Nope,
proposed.
It's BA 250017.
Oh, I'm sorry, I'm way off. 250017 and allowing the 1162 square foot of hillside disturbance outside of the lot's principal building envelope.
We have a motion by Member Ward, and Ron was going to state, I think, the square footage of the lot. Go ahead.
So it is 1 acre.
Okay, exactly. Okay, I thought so, but I just one clarification. Right, we have a motion. Is there a second?
Second.
And a second by Member Clapp. Rosalie?
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 3-0.
Congratulations.
Thank you, Chairman, members of the board.
You're very welcome. Move on to agenda item number 5, BA 250021, the Alanick property in District 4 in the Sun City West area. Joel.
Chairman Loper, members of the board. BA 250021 is a request for a variance to the rear setback requirement. Standards 25 feet. They're requesting 15 feet. So it's located at the end of a cul-de-sac in Sun City West. Lot remaining is originally platted with no significant alterations. The reason for the variance request is that an HOA requirement made by Sun City West HOA that accessory structures must be attached to the primary residence. If the structure is detached from the primary residence, the proposed structure would comply with all setback requirements. Therefore, Maricopa County doesn't enforce HOA or architectural design standards. Therefore, staff couldn't find a peculiar condition that exists that prevents compliance with the county zoning regulations. Appears the variance is sought solely due to this HOA preference and not due to site constraints. This time, I'm happy to answer any questions.
Thank you very much. You mean just being in Sun City West alone isn't the peculiar condition? Are there any questions of Joel by any of the board members? All right, I'll go ahead and open the public hearing. Is the applicant Greg in attendance? Come on up if you could and give us the correct pronunciation of your last name.
Olenich.
Olenich. I probably would never got that right. I apologize. Go ahead and give us your name into the record and the reason for your request.
Okay, first name is Greg, the last name is Olenich.
That's a great first name, by the way.
Thank you.
And then just go ahead and tell us why you're requesting the variance. Give us your justification for it.
Okay. Okay, first of all, for the existing layout, if I move the southeast, first of all, it's only the northeast corner of the building that will be in, I'm asking for the 10-foot variance. There's a 25-foot setback, and I just want 10 feet of that. And that's just for the corner of the building. So if I move the southeast corner of the workshop to the south by 10 feet, that only leaves a 2-foot clearance between the south side of the workshop and the block wall around the patio. And per code, I need 36 inches for a landing for the south side door. Currently, there's only 4-foot clearance between the wall and the proposed building. And it's only 35 feet if you measure from the 25-foot setback to the block wall around the patio. It's only 35 feet of a distance. And also the north property line, for some reason, they have that labeled as a backyard. It's actually a side yard. I have 5 sides to the property, and they are labeling my backyard actually is up against Old El Mirage Road. The property line on the north that they're calling a part of my backyard is actually the backyard wall for the neighbor on the other side of the fence. Also, the actual backyard from the fireplace to the 25-foot setback in the back is only 27 feet. So the workshop could only be 22 foot wide max, allowing for clearance between the fireplace wall.
Mr. Olenich,
Yeah.
I appreciate the cover of all the other dimensions and stuff.
Okay.
But as the way it was advertised, it talks about the setback to the rear or north. They specifically identified where that's happening of 15 feet or 25. That's the one that you're requesting, correct? That's the only one that's impacted by a dimension, regardless if it's the north or the side I'm sorry, rather, whether it's the rear or side or however it's identified, it's the setback to the north, correct?
It's the setback to the north.
Okay.
Correct.
Then that's good enough for us, whether it's identified which one or whatever the other setbacks are on the property. That's not germane necessarily to this request. So.
Oh, okay. Well, I just
We're
took the
good.
measurements just to let you know that I couldn't position it in the backyard.
Right.
And I can't position it on the other side because I would need a 25-foot variance instead of a 10-foot on the side that it's on. Plus there's light poles and mailboxes on the other side. So I have no access to the yard on the south side of the house. It's the
No, I
only place I
definitely
can put
appreciate
it.
the overview, and you can see from the photo that there's a number of things that would have to either be torn out or relocated to accommodate trying to put it somewhere else. Go ahead. Or is that all you had?
If that's all you're concerned about is the north wall, yeah. Because I got measurements and everything for all the way around, like I said.
Okay. All right. Are there any questions of the applicant by any of the board members? None from Member Ward. Member Clapp?
No.
All right. Is there anyone else in the audience who wishes to speak on this item? Seeing none, do we have anyone online?
No one online with their hand raised.
All right. Thank you very much. Go ahead and close the public hearing. This is in District 4, and given that if it were detached, as Joel said, it wouldn't require the variance, but it has to be attached per the HOA CC&R requirement. That's not, to me, whether that's a technically a reason or not, it is a hardship on the property owner that is not of his doing. Therefore, I support the variance, and I will make a motion to approve BA 250021, subject to the stipulations outlined in the staff report. It's a motion for approval by me. Is there a second?
Second.
I heard and saw at the same time. I will go with Member Clapp for the second. Because I got you last time, Fern.
I won't hold a grudge.
Good.
Go ahead, Rosalie.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 3-0.
Congratulations. All right. Item number 6 was withdrawn. Move on to item number 7, BA 250033, the Wiley property in District 1. Nick?
Yes, thank you, Chairman Loper, members of the board. So case BA 250033 is a request for a variance to permit a private pickleball basketball court on parcel 304-87056B with a setback of 4 feet from adjoining properties where a minimum of 20 feet is required in the R4 zoning district. So the applicant is also requesting a variance to permit a 3-foot front setback from the north property line where a minimum of 20 feet is also required in the R4 zoning district. Now, the north yard effectively functions as a rear yard for the property, but the property does have legal access from both the north and the south, so it is considered a through lot. Now, the court was built without permits and is the subject of an active code violation. 2 years ago, the previous owners built the court to a setback of only 5 feet from the west lot line and 4 feet from the north lot line. Code violation was opened on the property this past February due to citizen complaint. And on that note, since the staff report was published, staff received one notice of opposition from the owner of the neighboring property to the west, and it's this property from which the applicant is requesting the reduced setback. The neighbor's letter has been included with the provided handout memo. That being said, staff is unable to identify any peculiar condition facing the property. Staff is also unable to identify an undue hardship created by the enforcement of the zoning ordinance. The development of a primary use on the property, that being a residence, fulfills the general intent and purpose of the R4 zoning district. And furthermore, the code violation could have been avoided and the need for variance negated had setback requirements been addressed with review of a building permit prior to development of the court. That being said, if the board finds the applicant has satisfied the statutory test, the grant of this variance will memorialize the following. Item A, variance approval establishes a 4-foot setback for a private sports court for APN 304-87056B. And item B, variance approval establishes a 3-foot north property line front setback for APN 304-87056B. At this time, I'd be happy to answer any questions.
Thank you, Nick. Great overview. I do have a question, and maybe other board members do as well. So I truly wasn't aware that a court had to have a permit. Why would it need a permit, but a driveway that's concrete, those don't need permits, right? I can go out and pour a driveway in the county, correct?
Mr. Chairman, the flat work does not require a permit. Any fences, lighting, things like that require permits. The sports court, however, have setbacks in our ordinance.
Okay.
And those had to be met.
Because it's a use.
Yes.
Okay. All right. Any other board members have questions? Member Ward? No? Member Clapp?
No.
No. Okay. Thank you again, Nick. Great overview. I'm going to go ahead and open the public hearing. Is the applicant or applicant's representative, I have a Rustin Gannett in attendance. Come on up.
I'm the owner, David Wiley.
Awesome. If you could give your name to the into the speaker there and go ahead with your presentation.
Hello, my name is David Wiley, and my wife and I recently purchased this property. Rustin was the general contractor that didn't get the permits, but anyway, we fell in love with this property because of the backyard, the aesthetics of it, also to bring our families closer together. We moved closer to our kids. At the time that we bought the property, we in the seller's disclosure, there was a variance request submitted. And when I did the research, I understood about the code violation with the lights. I spoke to the neighbors about the situation. He was upset about the lights because they shine into his backyard. Also, the previous owner evidently liked to entertain a lot of company, and they encroach on his privacy on many occasions. So the lights have been removed and the code violation has been negated by that. Again, the sports court was part of the property. That's why we fell in love with the house. And it's a very, very good house for our families and everybody to enjoy gathering. Thank you.
Thank you. Are there any questions of the applicant by any of the board members? None by member Ward. Member Clapp?
Yes, I have a question. I know that there is a complaint about this. The basketball goal that's there on the west side of the property, was that there when the property was purchased?
Yes.
And, and have you discussed that with the neighbors about that, the proximity of that goal to their property?
In our discussions with him, he didn't mention that at all. He was mostly upset about all of the balls being hit into his backyard and unfortunately people trespassing to retrieve them. But I can tell you that with the use of this sports court, our kids are being taught respectfulness, and we adhere to that. So, but I wasn't aware of any issues with the basketball.
Okay, but it is very close to their property. Is there a net around it to catch any balls that would go into their property?
Yes, there is. There's a net. There's a 20-foot net between our property and his property to the west.
Is there also a wall?
Well, just the wall separating our properties, plus he built an additional 3-foot privacy wall.
So it's 9 feet, roughly a 9-foot wall between the properties and a 20-foot net?
Yes.
How tall is
net?
it? How tall is the basketball? I'm sorry. Go ahead.
No, go ahead, Member Clapp.
No, how tall is the basketball goal itself besides the net?
Typically, they're around 10 feet. 10 foot's the rim heights.
With the backboard, it's probably 12, 13.
Yes, sir.
Okay, that's the only question I have at the moment. I'm sorry I interrupted you.
No, I interrupted you. My apologies. It just made me think about that. So you've got between the pickleball along that property line, you've got a 20-foot net.
Mm-hmm.
And then between you and the property line, and then at the property line, there's a 9-foot wall.
Yes, that's the common wall between the two properties, plus he built an additional 3-foot privacy wall.
Sure, there's a permit and it's structural.
That's on his property. I don't know.
And then where the basketball court is, what's that condition like between the properties?
Well, the basketball court is actually part of the pickleball court.
Oh, okay.
It's not a separate.
Is it just one basketball hoop, one standard for that, or is it? I'm sorry, or is it two?
There's two.
There's two. They oriented east-west or north-south?
East-west.
East-west. So there's one right up against the property line.
Yeah. Yes.
I believe it's at least 10. The actual net or standard is, I think, about 10 feet from the property line.
Okay. Trying to make out here the notes. Could, if that was turned, so the slab, Nick or Darren, the slab needs to be moved to meet setbacks, not just like the basketball standard, the pole.
Mr. Chairman, the slab doesn't necessarily have to be removed, just the use of it as a sports court has to meet a 20-foot setback, the way the ordinance is written today.
So they could delineate it with its, like I've seen pickleball courts that have 3-foot chain link fence to cordon it off.
Striping, whatever they do.
Public pickleball courts do that. Basketball courts oftentimes have a fence or something. And could that be something you could accommodate? You'd have to make your slab bigger going to the east, but you'd have to partition it off to try to meet setbacks. I'm just throwing this out here. It's not necessarily where we're going, but I want to see if it's something you could do. You would, to meet setbacks, or at least try to meet or come somewhere in the middle, you would have to put a fence, another fence. You'd create an area where there's no pickleball, no basketball, and then eastward of that would be the pickleball and the basketball. You'd have to move the basketball standards. You'd have to put oh gosh, I forgot the word now. The net for the pickleball, but the area too, you have to move all that eastward as well. Create that Is there an aerial, Nick?
Chairman Loper, yes, I believe it's in the staff report. Let me check here.
I usually
Yes,
don't,
there
I usually
aerials
don't print
on
my
page
staff
4
reports.
of the staff report. It may be on the slides as well.
I thought that the question was a 20-foot setback from the rear of the property and not
Well-
the east-west setback. The east-west setbacks are only
Proposed use is a 4-foot where 20 feet is the minimum permitted, and then 3 foot on the north, which is the front yard. I think and clarify this if I'm wrong, Nick, it's 20 feet on the side and 20 feet on the north, which is the front, because you've got a double fronted lot. So it's 20 and 20. It's 20 on the side, 20 on the north, 20 on the west, 20 on the north. Sorry, I don't usually print these. Okay. Oh, then I've got it right here. Sorry. Thank you, Rachel. Thank you, Nick. So that's collapsible, the basketball.
yes.
When my boys were younger, I remember those. I also remember the neighbors too. Not laughing because it was funny, but just laughing. I can see that you've gone to some lengths to try to be accommodating, but I also appreciate the neighbors' concerns as well. Okay, any other questions of the applicant at this time? All right, if you could hold tight, I'm sure we'll have extra questions for you. This is a public hearing. I'm going to go to those that are in attendance first that I have a speaker request card for. And Terry Beebe, am I saying that correctly?
Really close. It's Antaray.
And Teray. I got the BB part correct, I think, because I know people with that last name, but
There you go.
sure, the first one.
I didn't expect you to get it anyway. Don't worry. All right. Am I close enough?
Yes, go ahead and give your name for the record, and then go ahead with your discussion.
Okay. Thank you. My name is Antaray Beebe, and I am the adjacent neighbor to the west of the subject property.
Directly adjacent to the uses then.
Correct.
Okay.
Yep. That is me. In the aerial photograph, the house to the west of it with the pool that's right next to their court, that's our home. So I initially filed the complaint with the zoning board back in February. And I also submitted written comments for the board's consideration prior to the hearing today. So I don't want to belabor all the points because I'm sure the board has these comments, and I don't want to stand up here and spend your time going on and on with all of the different problems we encountered with the neighbors having this full-size recreational basketball and pickleball court that's 58 inches off of the property line. It's probably a lot of common sense that indicates why that would be a problem. Probably case in point why the setback even exists. So we experienced numerous pickleballs and basketballs flying into our yard. So between just sheer like disturbance of noise and that kind of issue, right? We also had, like I said, basketballs and pickleballs flying into our yard, our pool. We're talking inherent safety risks for me and my family and my pets, property issues with our pool from the pickleballs constantly going into the pool, filtration skimming system, my dog is eating them. I mean, again, I don't want to go on and on. But the reason I really wanted to comment on a couple of things was, first, I noticed that when I submitted my written comment, it was actually prior to the staff report issuance. And so afterward, I saw that the variance was strictly requesting for the setback of the sport court and did not mention the lights or the height of that basketball hoop net appurtenance. So the lights, the poles were removed, and we sincerely appreciate that. But due to the proximity of the house and where these are located and the topography, we can see, and directly into the yard, that the concrete foundation footers for those lights, along with the metal hardware that would attach to the posts, is still in place. And then further, The hoops themselves, it looks like they did lower it to maybe that 14-foot or less requirement, but the net they attached to it, which does not function. I mean, I have a picture I took this morning. It pretty much functions as a bird outpost. The net hangs way down in the center, but even when it was being maintained, it doesn't function as designed. But I noticed the variance didn't touch on the height variance necessary for that too. So my ignorance involving the setback for a sport court variance, I'm not sure if all the associated accessories and the variances that would and go along with those are inherently approved if the sport court setback use is approved. But either way, I mean, my family has concerns about all of those items. And then the other point I wanted to make today was about the neighborly concern. So I feel compelled to mention this is definitely not like a neighbor dispute. I was shocked when I got to read the staff report and saw the variance application. They said there was no neighbors had a problem. So the previous neighbor was well aware of the problems. I guess he chose not to disclose that to the new owners for his own personal reasons. I have never even met the new owners. They did speak to my fiance and I was not home. My fiance told them all the problems we had, expanded on all the issues, didn't go into great detail because certainly not trying to discourage someone from purchasing a home. That's a legal issue. He was aware of the variance request, aware of the problems. They chose to move forward with the home anyway. That's their business. I'm sure they're great people with the best of intentions, but it's not really about who you are and your intentions. It's about the proximity of the court itself. The very weekend they moved in, I don't know if it was friends, family, grandkids, whoever was using the sport court. And we ended up with 2 balls in our pool the very weekend they moved in. I'm not even sure if the kids ever told them that because they never asked for the balls back, nor did they ever say anything to us. But I mean, it's pretty clear it's not about who you are and not your intentions, it's proximity. So for all of those reasons, I am respectfully requesting that the board please do not approve the variance. Thank you.
Thank you very much. Are there any questions of the speaker by any of the board members? Member Clapp? All right, thank you very much. We may have additional questions for you.
Thank you.
That's the only other speaker card that I have. Is there anyone else in the audience who wishes to speak on this? Just a moment. Do we have anyone online? Nadia or David?
Chairman, there's no one online.
No.
Okay. To the applicant, I'll give you 2 minutes. But not really in rebuttal. I really don't want to make this a neighbor versus neighbor thing, but go ahead if there's something you wanted to say. Mr. Wiley?
I apologize if the balls went into your court. I had no idea. If you had come over and told us that, we would have put a stop to it immediately. I'll be happy to take the net down if that is displeasing to you. I'll take the basketball courts down if that's displeasing. But the pickleball court was the whole reason that we bought this house. And then we talked to your husband and he didn't seem to have any other problems, but obviously we didn't talk to the person in charge, which we know are usually in charge. So thank you.
I appreciate that. I'll go ahead and close the public hearing then and turn over to the board for discussion and or a possible motion. This is in District 1. We don't have a representative here from that. A couple of things I'm going to say off the top. Number one, we have every once in a while something like this, and then the thing that bothers me the most is your neighbors. Right now, you live next to each other, and you may live next to each other the rest of your lives. Who knows? And so, you know, I'd like to see you work this out. It's a really nice neighborhood. These are really nice homes. This is sizable investment by both of you, certainly presently, and probably going to go up in value for a while. I appreciate that you bought the home for the pickleball court. I absolutely appreciate that it's an issue. Having been involved the last decade in developments with pickleball courts and opposing pickleball courts. I appreciate the noise with them. That you're absolutely right. That's become a big issue that wasn't here a decade ago or wasn't heard of. Tennis courts, there's the lighting, all that other stuff. As I look at the pictures, I'm not convinced that the netting is of sufficient type to keep a high-speed pickleball or tennis ball or racquetball or anything small enough from going through it when it hits at a high velocity. I'm very appreciative you took down the lights and that you're willing to do that, the basketball on that side. Because maybe just having it on the other side would be sufficient. Half court, people do it all the time. A lot of public parks are just half court basketball. I don't know what to do with the pickleball because you could make it legal with the setbacks. It'd be a burden financial to make that work. That would make it legal. It may not address your issue. But I would encourage you to look at a net type that would be, they make them that would stop a pickleball. I just don't know if this is it. A question for Nick and Darren, maybe Ron as well, is are variances needed for this pickleball net and the supporting structures? I don't think variances are needed for the basketball. This looks like the temporary kind that has the ballast that keeps it up. But if they decide to make a permanent, are they? And it doesn't have to be decided today. Is a variance needed for that wall that was put up, I think, by the neighbor, that now 9 feet, probably has needs to be a structural wall.
Yeah. Mr. Chairman, real quickly, maximum wall height in
residential.
Maximum wall height is 8 feet, except within the required front yard. There's some further restrictions, but maximum wall height is 8 feet unless you meet the principal building envelope. Then it can go up to the 40-foot maximum height permitted in R4, same as a building. Obviously, it'd be engineered.
Right.
There is an allowance for sports courts. So fencing associated with sports courts, they go up to, I believe, 20 feet within 20 feet.
Okay.
Yeah. Same with the lighting, can go up to 20 feet within 20 feet or at 20 feet. So the sport court, per ordinance today, the sport court has to meet a 20-foot setback. Other structures and buildings may meet a 3-foot setback if it doesn't occupy more than 30% of the required side or rear yards. Detached structures and buildings. So sports courts are treated a little different because usually there's fences associated with them, and the fences need to be higher than 8 feet. So the requirement is for them to be set back 20 feet.
Okay. There's a lot to digest here. What I would like to see happen, this is me, I'm one of 3 today, is I'm thinking of having this continued at least to the next hearing, maybe possibly to the next one after that. I would like the 2 of you, include your fiance and whoever you need to politely meet and see if you can come up with a way. There's going to be activity on his property because he can move things to make them legal, but they'll still likely happen. And I'd like you to try to figure out a way to make your neighbor as happy as possible. Because I can tell you, if I was in my backyard and I was being bombarded, even if it happened once a day, if I'm laying at my pool and I'm getting hit with a pickleball or a basketball, or if I'm hearing that bounce at night and I'm trying to relax, not a happy camper. And so you need to work on some timing restrictions, lighting. It looks like you may have accomplished that, but there's still building mounted lighting. I'd like to see this come back with you guys having tried to work on something. I'm not naive and think it's going to be, you're going to hold hands and sing Kumbaya, but maybe it's a happy medium. And so that's kind of my thought. I don't know if any board members would welcome that. Right now, as it stands, I'm not in favor of the variance but I don't think that that solves the issue. And I don't know if the Board of Adjustment is here to play HOA president. Really, we're not. But this might be your best chance to the neighbor to try to get some resolution to it, and to you as a property owner to not have to tear up your whole backyard and spend a lot of money that you wouldn't necessarily have to. So that I'm throwing that out there. If any other board member supports that, then I would appreciate a motion that way. Otherwise, we can hash this out. Member Ward.
I just, a couple of comments, maybe a question to you. If we disapprove the variance and this, the court needs to move, in my personal opinion, and maybe I'm wrong, it's not going to cut down on really the initial problems. You still hit something, like you said, you hit a pickleball hard, like 20 feet away, it's still going to go over the fence. The noise is still going to be an issue. I appreciate the fact that Mr. Wiley's willing to take down the basketball, half of the basketball courts. And I'm wondering if something like I guess I'm picturing like a baseball hitting a batting cage where you have the hard chain link and then you have the mesh inside of it. If something like that might be a possibility.
Member Ward, you're on to something, and nearly none of this is really land use or variance related. And I'm just being transparent about that. I'm just trying to help two neighbors come up with it. If he brings it into compliance, or if we approve the variances and we just don't address any of the issues between the neighbors, this is all a private matter. You guys could go to court or not to try to resolve these. They're nuisances. My only goal in throwing out the continuance is so they could try to, is that there's some hammer, if you will, to try to come to some resolution. Yeah, ideally, if you look at public parks, there are chain link fences around backstops. There are chain link fences around basketball courts. There's chain link fences around pickleball and tennis courts. That doesn't stop noise. That just keeps balls contained. Distance helps with noise, but doesn't negate it entirely. Sound walls don't negate it entirely. There's going to be noise. The only thing you can probably do is regulate the times. I'm just hoping they maybe could come to some happy medium for that. You know, there are business and school hours when maybe people aren't home and it could happen. I don't know the ages that use these things or occupy either residence. So I just food for thought.
I would be in favor of a postponement if they're willing to do that.
I'll throw it back to you, Mr. Wiley. Let's see what Member Clapp has to say first. Member Clapp?
Yes, I'd be willing to continue this to the next available date or possibly 2 dates. This whole problem came when the sports court was built without a permit, and there are requirements for sports courts that obviously were not met. So what can be done to resolve this issue now without having to cause a great deal of movement in this court? And a lot of it has to do with the screening of the property to keep at least balls out of the neighbor's property. Moving the basketball goal, I think, is a great move, because in looking at the pictures, I certainly wouldn't want to live next to that for a variety of reasons. So I think there's some more discussion that needs to take place between the staff and the applicant about what can be done to make this court acceptable in this backyard to both the to comply with the ordinance as well as to help with the neighbor's problem. So I think continuing this with further discussion on the part of Mr. Wiley is probably a very good thing at this moment.
Okay, I think there's general consensus on that. And Mr. Wiley, I think we all recognize that you bought the home. It was already in place, the pickleball. Like you said, you bought it because of the pickleball, thinking that it was legal. not knowing that. My question for you and for the neighbor is 30 days roughly sufficient time to work? Remember, you've got school starting up, vacations people take into July, beginning of August, or is 60 days probably better? Just a nod either way. Okay, so somebody want to make a motion to continue this to the next meeting in August?
I can make that motion. I move that we continue case number BA 250033 to the next Board of Adjustment meeting in August.
We have a motion for continuance to August. Do we have a second?
Second.
Second by Member Ward. Rosalie?
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for a continuance by a vote of 3-0.
Thank you both. Just trying to come up with something good here. Not solving the world's problem. This isn't the Middle East for sure. Move on, next item, BA 250035, the Craig/Thornton property in District 2. Nick?
Thank you, Chairman Loper, members of the board. So BA 250035 is a request for a variance to permit a detached accessory garage and storage building on parcel 220-07023E with a rear yard coverage of 57%, where a maximum of 30% is allowed by right. So construction of the building began without permits and is the subject of an active code violation. The owner's previous contractor applied for a permit shortly after the violation was confirmed. However, according to the owners, their original contractor submitted falsified site plans showing a structure that conformed to zoning requirements and subsequently continued building the structure out of conformance with those plans. As a result, plan approval expired and the permit remains in review today. The building under construction now exceeds the 30% coverage allowed for an accessory structure in the rear yard. The owners hired a new applicant to evaluate the work completed and prepare plans. And per the amended site plan that was given to us for this variance, the accessory structure covers approximately 56.7% of the rear yard. So for the variance, we're rounding up. That said, staff is unable to identify a peculiar condition facing the property, and we're unable to identify an undue hardship created by enforcement of the ordinance. The development of a primary use of the property, again, that being a residence, fulfills the general intent and purpose of the Rural 43 zoning district. Furthermore, the code violation could have been avoided and the need for variance negated had the owner's original contractor acted in good faith to obtain a zoning clearance before commencing construction and then construct the building to MCZO requirements. That said, if the board finds the applicant has satisfied the statutory test, the grant of this variance will memorialize the following. Item A, variance approval establishes a maximum allowed rear yard coverage of 57% for APN 220-07023E.
Thank you, Nick. Are there any questions of Nick or any other staff at this time? I do have one, just clarifying what you said. The previous owner submitted the site plan incorrectly showing a detached structure that met the lot coverage. Then this person purchased the property, found out that it was incorrect.
Actually,
Roughly.
Chairman Loper, it was actually the same owner. It was their previous contractor. Their previous contractor had submitted the permits on their behalf very shortly. The construction wasn't even, from my knowledge, wasn't even that far along when the violation was reported. And they very quickly thereafter the violation was reported, submitted the building permit, but their contractor, I believe they got their plans approved by our zoning division, but when they proceeded to construct it, they constructed it very out of conformance with what the site plans had showed. The site plans did show it meeting the rear yard coverage requirements, but they built it out of conformance with those plans, and the building ended up well exceeding the 30% rear yard coverage allowance in the zoning ordinance. And after that, the owners, still the same owners as of today, they hired a new applicant, who is the applicant with this case as well, to evaluate what was already completed, prepare new plans to submit to our zoning division. And when our zoning division notified them that they exceeded that 30% rear yard coverage requirement, then they came in for this variance request.
So they tried to make it right. Wasn't necessarily their fault. It was just, clearly nearly double what it should have, what it probably showed on the initial submittal.
Chairman Loper, that's correct.
Thank you very much. Go ahead and open the public hearing. Is the applicant Earl Bakken in attendance.
I'm Blake Craig, Blake Craig, the homeowner.
Come on up if you could. Provide your name into the microphone, please, and go ahead with your presentation.
Certainly. My name is Blake Craig. Chairman Loper, members of the board. As I mentioned, my name's Blake Craig. I'm here with my wife, Whitney. My wife and I have never been involved in a building project before, and we acted in good faith and hired a licensed contractor to design and build an accessory building for us. We were led to believe that everything was being done per code and in good faith. We had no idea that our contractor had been lying to us. We had no idea that he proceeded to locate the building in violation of Article 1106.2. And we had no idea either that he would run off with our money and leave the accessory building in violation of Article 1106.2. To say that this has been the most difficult and worst experience of our lives would be an understatement at best. We saved for decades to be able to do this building and thought we were fulfilling our dreams. Instead, we faced the nightmare of catastrophic financial loss. We're asking that you grant us a variance to allow us to complete the project. Doing so will not impact anyone but us. A variance will have no negative impact on our neighbors or surrounding areas. And we thank you for your time and consideration, and happy to answer any questions that you may have.
Thank you very much. Are there any questions of the applicant by any of the board members?
Yes, I have some questions.
Go ahead, Member Clapp.
Mr. Craig, when you hired the new firm to continue on after the old contractor left, did you discuss with them the original plans that the contractor had sent through the county that got approval? Was that discussed at all about how could you get close to complying to that, or did they just start out with a brand new design?
No, no new design at all. This gets I guess a little bit complicated in the series of events. But when we found out, where do I start here? Our first contractor ran out on the project in September or November of last year.
Yes.
And at that time, we were left with absolutely nothing. So what we needed to do to proceed forward is find a new contractor. And the new contractor came in and spoke with members of the planning and development department. And they requested that we get engineering and architectural diagrams done with the building as it currently stood. And so at that point, we enlisted our architect who's here with us today and an engineering firm to go back in and basically redraw everything that had already been done. Does that answer?
Yeah. So how much of the building was completed when you hired the new firm?
There has been no construction of the building since we hired the new firm. But if you take a look at the photos.
How much was completed by the original contractor?
100%.
So
100% of the work that there's concrete framing, lathe, stucco, electrical. I mean, there's an enormous amount of work has been completed.
Okay, the report had said it was partially completed, and I wasn't sure how much. You just explained how much it was. Did the new architectural firm understand or discuss with the people in the county when they took over that they could not exceed the 30% maximum coverage of the rear yard?
Maybe I should back up. We had no knowledge that the building had been built in excess of the rear yard coverage at the time we enlisted the architectural firm and engineering firm. We did this on request of the county, and at this point in time, we thought everything had been done with compliance.
So you were not told that it was exceeding the coverage?
No, we were not.
Okay, that was one of my questions, and let's see if I have anything else. I think that's it. Thank you, sir. I appreciate your comments.
I do have two questions. One is, if you haven't already, I would hope you'd go to the Register of Contractors on your original person, if they were legitimately licensed, even if they weren't, and then to the Attorney General's office. Hopefully the Attorney General can actually focus on a lawsuit for somebody in the state instead of everything going to the federal level. That's my only political statement. And then second is, if this were to be approved, I would like to see it, I'd like to see it painted or somehow so it matched more the house. If you look to the property to the north, they have a building similar.
Please let me comment on this point.
Yeah,
The
go
building
ahead, go right ahead.
is not completed in any capacity as you see it in the picture. It's designed entirely to match our house. So it will be painted in the identical colors of the house and be beautifully matched to our property.
Okay, because I figured probably that was it. And then
It
also,
just hasn't been painted in that picture. That's just stucco.
yeah, when Nick was talking about the partial construction, I figured it obviously didn't get a final because the county wouldn't final it without a variance or without it meeting lot coverage. So there's probably a number of steps to go through still.
Oh, yeah.
Okay, all right, go ahead and have a seat. We may have other questions for you. This is a public hearing. Is there anyone else in the audience who wishes to speak on this? Seeing none, do we have anybody online? Nadia or David?
Nobody online indicating they wish to speak.
Good deal. I'll go ahead and open the public hearing. Turn this over to the board for discussion and or a motion. This is in District 2. Member Clapp?
I'd like to hear a little discussion from either one of the other two before I make a motion. I'm leaning toward approving this out of sympathy for the owner and what he's gone through. It's unfortunate that this has proceeded the way it has, but short of having to demolish part or all of the building, I don't see any resolution here other than giving approval. But I'd appreciate your feedback as well.
And I'll provide, but Member Ward has her hand up first. Go ahead, Vern.
I totally agree. That was the same. I got the impression that the applicant has been trying to follow rules since the property was purchased and just ended up in a horrible situation that if we don't allow it, it's just going to cost him a lot of money.
And I'll chime in and I'll say exactly the same. Unfortunately, bad actors cause his family to spend a lot of money and now have to go through this process. And I hope for a good resolution at the end of the day. And I'll also note that given the property to the north and some others in the area, it's not out of character. It is nearly double the lot coverage, maximum lot coverage, but the character of the area seems to support it. So I'm also supportive of the variance. With that, I'll entertain a motion.
All right, I will make a motion to approve case number BA 250035 with a variance of the rear yard coverage of 57%.
We have a motion by Member Clapp. There's second. Second by Member Ward. Rosalie, when you get an opportunity.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 3-0.
Congratulations and best of luck. I hope this goes well for you both. Move on to the next item, BA 250039. And, you know, I'm always thankful for Protective Services with our Sheriff's Department for being here for us. I will not tell a soul if you sit down. You've standing for nearly 2 hours. Bless you both. Go ahead, Daniel.
Thank you, Chairman, members of the board. Case BA 250039 in District 4 is located at 24812 West Patton Road at the southeast corner of Dale Lane and 248th Drive in the Whitman area. The site is approximately 61,000 square feet, and the request proposes a front yard setback of 26 feet where 40 feet is the minimum required. The applicant proposes a residential addition of 798 square feet. At the time of building permit review for the addition, it was noted that the addition encroaches into the front yard setback. The addition would lie 26 feet from the easement for Dale Lane and encroach 14 feet into the required front yard setback. On August 13, 2020, the Board of Adjustment granted variances for a waiver to the street side setback off of 248th Drive to the west for an existing detached accessory structure and a reduced interior side setback east to 10 feet for the residence's existing encroachment into the side yard due to an unregulated lot split. After reviewing the submission, staff is unable to identify a peculiar condition of the property. The lot is already developed with a single-family residence and several accessory structures. Alternatives exist for development of the site without encroaching into the front yard setback. The owner can take advantage of the waived street side setback and enclose the attached garage, and extend the residence up to 49 feet to 248th Drive. There are no observable topographical or physical constraints that prevent reasonable development of the property. I'm happy to answer any questions.
Thank you, Daniel. Great overview of the request. Are there any questions of staff at this time? All right, seeing none, thanks again. Go ahead and open the public hearing. Is the applicant, Mr. Crow, and/or representative in attendance and wishing to speak?
Chairman, I have Zachary Crow online. Let's see, I have him unmuted. He also needs to unmute on his side to be able to speak. There you go.
Go ahead, Mr. Crow. Just provide your name for the record and provide your overview of your request.
I do have him unmuted. It shows his mic is accessible. We're just not hearing him. I don't know if he's got a double mute somehow.
He may have stepped away and just not aware that he's up yet.
Well, he had to unmute on his side, so I assume he's trying to get it connected, but we're not hearing him, so.
Give him a moment. Just a quick question to those here in the audience. Are you here for the little property? Okay. We'll give this just a few seconds and we may jump to you. And then is there a way to notify Mr. Crow that we'll come back? Oh, you got him online?
I'm gonna call him right now.
Oh, okay, good. Go ahead, Daniel.
Hi, Mr. Crow. I have you on speakerphone in front of the commission. If you'd like to start with your request.
Yeah, obviously you can hear me on the other one. Can you hear me now?
Go ahead.
My name is Zachary Crow. It was referred to as my rear yard. I mean my front yard. I believe that's my rear yard. I don't know if that matters at all. On that side, on Dale Lane, Dale Lane's unused. I'm at the end of the dead end road. On the Dale Lane side, I have a 25-foot easement and 40-foot setback. I'm asking to essentially cut into 15 feet into the setback to put an addition onto my house. I have a grown family. I just got married and I now have 2 additional children. Just trying to add an additional room. I've already converted my garage into an office, and there is a permit was done and approved to the county for that. Like I said, it's a dead end road, so nobody will be affected. And obviously, I will still, with this new addition, instead of 65 feet total access, it would be down to 51 feet. And the only one that would have to access that would be utility companies, but they would be able to access it from either direction. No neighbors, no utilities, no anyone would have it. They would have no effect.
Thank you. Are there any questions of the applicant by any of the board members? All right. Anything else you'd like to add, Mr. Crow?
there anything else you'd like to add, Mr. Crow?
I'm sorry, I couldn't hear you.
Is there anything else you'd like to add, Mr. Crow?
No, you heard everything I said.
Thank you.
Okay, yeah, just if you wouldn't mind, Daniel, keep him on just until the end of this. All right, this is a public hearing. Is there anyone else who wishes to speak on this item? No one in attendance? Anybody else, Nadia or David, online?
See, no one else beside Mr. Crow.
Okay, go ahead and close the public hearing. This is in District 4, district I represent. I have to confess, I did not hear it extremely well, the whole presentation, but going back to the aerial photo and looking at the excerpt of the site plan from here and understanding that these corner lots have the way the ordinance is interpreted. I don't have an issue specifically with the variance request. I'm inclined to approve it. And as I understand it, Daniel, this is an existing structure.
It's for a new addition off of an existing structure, correct?
Thank you. A new or an addition off an existing structure, easy for me to say. Thank you. But I am in support of it. Any other board members have any comments? All right, go ahead, Member Ward.
I'm waiting for your motion.
All right, I will move that BA 250039, also known as the Crow property, be approved per the stipulations outlined in the staff report. Is there a second? Second for Member Ward. She was waiting. She was on the hot button. She's going to be on top of it.
Second.
Mosley?
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 3-0.
Thank you and congratulations, Mr. Crow. Best of luck with your project. Thank you for your patience. We're moving on to the folks in the audience. Item 10, BA 250040, the Little property in District 3. Martin, it's yours. Thank you for being patient. Thank you for being patient.
Good morning, members of the board. This is BA 250040 Little property. The site is located a half-mile south of the southeast corner of 19th Avenue and Joe Max Road in the Phoenix area. Next slide, please. The applicant proposes to demolish the existing home on the lot and replace it with a new single-family residence. The current plan is to add earth and fill to part of the building pad, which will increase the height of the home from 30 feet to 32 feet above the natural grade of the lot. Next slide, please. Since the maximum height in the Rural 43 zoning district is 30 feet above natural grade on subdivided land, the applicant is requesting a variance to increase the maximum height on this parcel to 32 feet above the natural grade. The applicant's architect believes that this addition of earth and fill is necessary to address slight undulations on the lot and create the aesthetic appearance of the new home. Based upon what the applicant has submitted and the staff analysis of this report, staff offers the following. After reviewing the submission, staff is unable to identify a peculiar condition on this lot, since the lot is a standard rectangular shape and relatively flat without topographical features. Staff cannot identify any unnecessary hardship created by the application of the ordinance requirements that would prevent reasonable development on the site. And the property owner plans show that the increase in building height is due to imported fill dirt for the proposed design, and thus any hardship is self-created. There are alternatives available that would alleviate the self-created hardship, such as removing the earth and fill from the building pad or lowering the west rooftop parapet over the fill area by 18 inches, as this feature is simply for architectural aesthetics. If the board decides to vote to approve this variance, then the approval will memorialize a maximum height of 32 feet above the natural grade for this lot. This concludes staff's presentation. Thank you.
Thank you. Great presentation, Martin. Are there any questions of staff? I have a couple, but I'll come back to it. Member Ward? Member Clapp?
No.
I'm going to ask a couple of questions I should know the answers to, and by virtue of this application, that should be my answers as well. So I thought that height is not measured by adjacent grade,
That's incorrect. It's actually done by the natural grade.
natural grade.
Yeah.
And there's not an FCD requirement that that the pad, the finished floor, needs to be 14 inches above the outfall of the lot.
Mr. Chairman, there are requirements to be a certain level of above inundation, but when we measure height in subdivisions, it's from finished grade. In unregulated land divisions, it's from natural grade.
Okay.
And in hillside areas, it's from natural grade rolling as a cross section through the building.
Okay. And then parapets, is it the parapet? Also, I mean, is the roof itself at 30, but it's the parapet?
Parapet, actually.
And those are not exempt. Like sometimes you'll see parapets are.
The only thing that'd be exempt would be like maybe like a rooftop feature, like like a stairway to get up to a rooftop terrace or something like that, or an elevator, a shaft.
In this case, it's not if it's a screening, like you'll see it where
That was not included.
It's to the top of the parapet.
Top of the
Not-
parapet.
And then if you could go back to the aerial photo.
No problem.
So right there, is that building, that white building looks like it has solar panels on it? I guess I could put on my glasses. That's on the same lot, correct?
That is correct.
That that looks to be higher. I realize they're taking out that single-story building. Does that not set a precedence for height?
Well, based on what we've researched, that does have building permits and it was at the correct height. And
Oh, okay.
we
Okay.
did have a stipulation on there that it was only supposed to be used for residential use.
I was trying.
Right, no problem.
Okay. All right. Never mind. That's the end of my questions. I'll go ahead and open the public hearing. Applicant, or representative want to come up and give us an overview? Foam core, somebody after my own heart. It's been a while.
Hi. Good afternoon.
If you could just provide your name for the record.
Lance Little.
Go ahead with your presentation, Mr. Little.
Sir, so yes, this is my shop. The shop is 30 foot and we always intended to put the house in front. This is my dream home that I'm building. I've lived on this side of town since I was 10 years old. I've progressed. We started a masonry construction company. I'm an owner builder, so I'm building a masonry home in front of this, which is going to accent the shop. The piers on the house have the architectural block on them, and the whole house, just the piers have it, but the whole house is going to be architectural. So it's like just a package that's just going to be monumental. It's just going to be absolutely beautiful. So I've been working on these drawings for 4 years. And my architect took what arose this whole situation, I believe, is the architect took the height code off finished floor instead of natural grade. So that was like the red flag that brought this whole thing up, because it was too high. It wasn't from finished natural grade. It was from finished floor. So that's how the plans were drawn. And through this 4-year process of getting everything absolutely perfect, and me being a mason, and the heights and joints lining up and block work and everything, every single, it would literally be impossible to redo these plans. It's like to the point where, you know, I'll go on further about this, but I've already bought the garage doors. They're 10-foot garage doors. The bottom windows I've purchased when I built the shop so I could get a better deal. Those are 10 foot. The second floor ones are 10 foot. It has a mezzanine on the plans that goes from the second floor, and the mezzanine connects over to the mezzanine on the shop. It's not as easy as just lowering the parapet, because the parapet is exactly the 36 inches I need for a safety rail, and there's a patio up on the top deck. I mean, this thing is so entailed, but let me just throw another few talking points out here. The 1'8" of fill, I think, is not as harsh as it's been presented. We put the house as low as we could from the north east corner and just went straight across. It's a big house. It's 80 foot long and about 45 foot wide. So when you go from that diagonally from one side to the other side, that's where the worst of the fill is, because we have to make the house pad level. And then secondly, There's a, that's not on the drawings because they made us take them out because they didn't get it engineered yet. There's a giant pool that goes in between the shop and the house. So it's just one big, just lounge area inside there. And, you know, I worked extensively with my civil engineer on making all this work on the lot. So the water goes around that area and the water doesn't flow through the pool area. Also, you know, you guys said it was relatively flat, which it is, it's flat, but it has a 4-foot slope from one end of the property to the front. And, you know, I know that because we got the permits and everything when we built the south wall. And it also slopes from north to south. So, you know, trying to level some structures this big becomes a little bit challenging. And one thing I think is a very important thing to note is the house is 1 foot 4 inches lower than the shop when it's finished. So it's not like I'm building a house that's even bigger than the shop, just with the flow of the land and everything else. I don't feel it's going to be an eyesore to anybody. I don't think anybody would ever know about this outside this meeting once this is built. And I think it's just going to be a beautiful, iconic structure in this neighborhood. And it would just be a shame if it didn't get built. But I'm getting older, and I wanted to do this 4 years ago, and my architect's retired now too. So I mean, I wouldn't even, I don't have the energy, time, or money to do this. I just asking for some sympathy and just, it's really, it's like 6 inches over, you know, and then maybe a foot on the very lowest end. It's not 32 foot in actuality.
All right, thank you. Any of the board members have any questions of the applicant?
No.
It looks like a marvelous home, and I'm always happy when people can build their dreams. Mine's, well, I could maybe afford an aluminum shed. Is there anyone else who wishes to speak on this item? Do we have anyone else online? All right, I'll go ahead and close the public hearing and open it up to the board for discussion and of possible motions in District 3. We don't have a representative on the board from District 3 here today. I do agree that some of the topography and the way that the way he's trying to do it with the matching grade for the building does present some difficulty in trying to get it to align, and also the way that the county defines building height from natural grade doesn't always work for every building such as this one, or every construction technique such as this one. I don't have an issue with this particular variance, so, but that's me. I'll turn it over to the board for other. Member Ward. You're muted. Don't hear you.
Sorry.
Okay, there you go.
Sorry. Okay, I have a question of staff, and I'm just wondering, is the 30-foot rule, what is the intent of that? Is that to prevent like a 2-story home, or is it a safety type issue?
Mr. Chairman, we don't have any restriction on number of stories. The ordinance used to indicate in rural and residential zoning districts, maximum 2 stories, but we just go by a maximum height. And the difference in the way we measure height between hillside areas and non-hillside subdivisions is simply to give some allowance for maintaining that hillside slope. Outside non-hillside would go from the lowest adjacent point to the highest adjacent point, whereas in the hillside, it's a rolling cross section, which allows you to be 30 feet as you climb up the mountain, so to speak. I don't know if I'm answering your question, but
this is a hillside considered to be a hillside.
I was looking at kind of intent, and so your explanation leads me very much to follow Chairman Loper's. I can't see where it'd be detrimental. So,
okay.
Yeah. And that was my only comment. I'm sorry. Thank you.
I do believe in general, although the purpose of the code in general is public health, safety, welfare, convenience, I believe the heights, much like a lot of our development standards are bulk of structure on a lot, and they are not all furthering a public safety issue other than in general, collectively, they promote the public health, safety, welfare, and convenience.
I believe it's probably been 30 feet since it was adopted in 1969. Yeah. Any comments, Member Clapp?
No, I will support this case also because I think the explanation of how this house is being built in conjunction to the building next to it makes a lot of sense to me. And as Board Member Ward mentioned, there's no detriment here to anyone, and so I don't see a reason for not approving this.
I'm sorry, I do need to correct something.
Yeah.
I explained the difference in how height is measured. This is not a hillside lot. I apologize.
Okay.
There is fill being brought in. I don't know if it's for the purpose of raising it above inundation, but that is the explanation for the increased height.
I think he explained it was really to match the existing building because he has a connection that goes to it. Correct?
There's a corner, we took the very corner of the lot. I don't know if you guys seen have you seen the renderings of the new?
You paid for it. You might as well show us.
Where's can I see that?
And I know that wasn't cheap because that's what everybody used to use.
Well, the very corner of the house over here, we put that as low as we could without getting water into the area. So, and we're not bringing in fill when we dig the footings and stuff. I mean, we put that as low as we could. That finished floor is only 6 inches above grade right there. And like I said, we brought this up. We did draw it wrong because our architect went 30 foot above finished floor instead of 30 foot above grade, and we probably wouldn't even be here right now. When, you know, if you look at even on the civil drawing that you have, there's areas where we're not bringing any fill. We're basically just leveling the pad right there because there's some natural fall. I have to bring in fill or the house would not be level, but I'm only bringing the fill on the north side. And you know, once again, I 4 years of drawings and it's lower than the shop. The house is lower than the shop that's already there because of the fall of the land. I just don't see where it would impact anyone in this situation. I'm just asking for forgiveness so I can move forward with this. And it's not 2 foot. It's not that far. It's like maybe a foot on the one end.
Member Ward or Member Clapp, or either of you want to offer up a motion?
I'll make a motion.
Okay.
I move that we approve BA 250040, varying the height of the building on this case to 32 feet.
We have a motion for approval by Member Clapp. Is there a second?
Second.
We have a second by Member Ward. Rosalie?
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for an approval by a vote of 3-0.
Congratulations. Good
Thank you,
luck
sir.
with your
Appreciate
dream.
it. You guys will love it. Trust me.
I thought we were over, but I forgot we continued to. BA 25, item number 2, correct? BA 250002, the Thompson property, District 2. This is the one with the lot coverage. Did we ever get a Mr. Thompson online?
Mr. Chair, we did contact Mr. Thompson. He is available if we give him a call.
Okay. Darren? That's a look of joy. Do you want to go ahead and give him a call?
Hey, hello? Mr. Thompson, you're in the Board of Adjustment hearing.
Yes, I'm not having lunch with my wife.
He's on. Would you like to?
I can hear you, but I can't hear anybody else, unfortunately. But I guess I can go ahead and.
So Mr. Thompson, Ron already did a presentation on this, on the rear lot coverage. If somebody could bring up the aerial of that again, or the site plan.
Can you hear Mr. Tom?
It was really, sorry, it's really hard to hear. I'll try to listen a little bit better. Can you repeat that one more time?
Yeah, just go ahead and present your application.
Okay. As per my last visit there, we didn't know whether the building was going to qualify to be built on the property. Joseph Mueller at the time did the math afterwards and said the building qualifies to be there as long as it's 16 feet off the west wall and I take down the yellow building. So I can build the building there under those perimeters without any variances or anything. What I'm asking for from the county is it possible to do either 5 or 10 feet off the west wall, because it's really just an unusable area and it shouldn't really affect any neighbors or anything. So that's all I'm asking for. I can go 16 feet now, just asking whether it'd be okay to go 5 or 10 feet. That's it.
Are we on the
Mr.
correct?
Chairman, for the applicant's benefit, the issue is not the setback. The issue is the amount of territory within the required rear yard that he's
Right.
occupying with building. Ordinance allows up to 30%. He's at 60 plus. He can maintain his existing building dimensions if he moves the building 16 foot from the lot line instead of 5 foot. That's what Joseph was getting at. The problem, if he takes down the primary building that's already there, he will not have a primary building, and primary buildings have to be completely, if this is going to be the only building on the property, it's going to be the primary building, and it has to be completely within the principal building envelope, which means it has to meet
no.
the.
Sorry, but that's incorrect. There's a yellow shed that's attached to the main structure. I got to take the yellow shed down.
Okay.
And Joseph said that with taking the yellow shed down and moving 16 feet in, I can build it existing.
Yes.
What I'm asking, so the yellow building's coming, the little yellow shed's coming down, no matter what. But what I'm asking for is a 5 to 10 foot, whether you guys will allow me 10 foot or 5 foot off of the west wall. The building can go up one way or the other. I'm just trying to ask for either extra 5 or 10 feet.
So you understand that at 16 feet setback, a detached structure at 16 foot setback, your existing dimensions you're proposing are fine. You'll only occupy 30% of the required rear yard. You do understand that, correct?
Yes, correct.
Okay.
Yeah, I can do 16 feet off the west wall, correct.
But he still would need the lot coverage.
No, if he's 16 feet, he's fine. But what he's asking for is your indulgence in a setback of 5 or 10 feet as opposed to 16 feet.
Can we do that? Because it's advertised for a lot coverage.
Right.
It's the same issue. It's not, the setback is not the issue. The issue is the lot coverage.
Okay.
If he moved it 5 or 10 feet from the property line, he'd have a 48 or 32% coverage within the setback area.
Go back to that exhibit that had the different dimensions and lot coverage. Yeah. Okay. Okay.
So what Ron has calculated, if you were going to award a variance based on certain setbacks, he's got what the rear yard calculation would be at 5 feet, at 10 feet, at 16 feet.
Okay.
15 feet would be 48%.
So it's almost a issue of semantics. It's where he's legal if he places it one way, but if he wants to place it where it's most advantageous for him, he needs the lot coverage variance.
Yes. If you were willing to approve like 48, just for example, if you were willing to approve a 40% rear yard coverage variance over the required maximum 30%, you would just word the approval that you're awarding a maximum 40% rear yard coverage. That just happens to equate to a certain setback if he wants those dimensions. He can meet that however he wishes.
Okay, but his maximum request right now is the 64%. Okay. Member
Mr.
Clapp, go
Yeah,
ahead, it's in your district.
I got a question. Mr. Thompson, why did you not request that when this came back to us? Because as I understand it, various options were discussed with you and you did not like any of those options and you wanted to come back and ask for the 64% variance. So now you're asking us to make a change on the fly when we thought you could resolve this with the staff member, but apparently you didn't. So I got a little problem with now changing this to 40% when you're asking us, when this case right now is requesting 64%, if we just leave it where it is and don't give you a variance, then you're just going to have to build it 16 feet to, from the west, and you don't need a variance. And that's the way I'm leaning right now because you didn't make any requests like this before this came back to us.
Yeah, at the last meeting, I did not know I could build 16 feet off the west wall. It was after that meeting, Joseph Mueller, my representative with the county, told me after that meeting was over, he goes, I'm surprised they didn't approve it, but I did the math and if you do this, you can build your building. And I said, well, okay, so I can build the building there 16 feet off the west wall. So if I come back and I just ask for a variance, because I can put the building there anyways, I would just see if I can move it back 5 to 10 feet. And that's what I'm asking for. If I can't, I'll build it 16 feet off the wall. The building's going to be there. I'll tear down the other structure and it'll be fine. I'm just asking for the variance.
I understand, but I believe you should have come back with a change in the request for your variance. That's what you're asking us now, but if you had just agreed to the 16 feet, if you had just agreed to move the building in the first place, you wouldn't even need to come back to us for a variance. And that's what we had thought you were going to do when you had the case heard last time. So I understand what you'd like to do, but it's not exactly what you came back requesting.
Well, ma'am, I didn't get that from the last meeting. The last meeting, I didn't know what was going to be approved. It wasn't until after the meeting, Joseph Mueller told me, if you do this, your building can be approved at 16 feet. That was never told to me at the last meeting, just to be clear. Okay. I was told, why are you building such a big building? These are the questions that were presented to me. It's like, and I'm like, okay, well, this is the building I want to build. If he gave me the parameters of which I can build it, 16 feet. So my point today of coming to the board again is to ask, is it possible to move it 10 feet off the back wall versus 16 or 5 feet? Because it's just a dead area that only weeds are going to grow. It's not going to be accessible by anybody. So I'm just trying to utilize the best of the lot to my ability. And that's what I'm asking the county for today. I'm sure it's just a yes or no with you guys, and that's all I'm looking for.
Okay, I'll open it up to let the other people ask questions on this also, because I believe that Chairman Loper was not in that last meeting, so he may have some questions.
Yeah, I was not here last month. Historically, I've been consistent that that the impact to the neighborhood, the impact to the lot is the same with or without the variance. So therefore, I don't have an issue with the variance as requested.
At the 64%?
Correct.
Okay.
Member Ward, do you have any comments?
I do not.
Maybe the deciding person.
And Darren, I believe you said that the lot coverage would be 40% if he moved the building. Is that correct? If he does what he wants to do, it would be 40% coverage and not 64%.
Yeah, at a 5-foot setback, the existing dimensions that are proposed would be a 64% rear yard coverage. At 10 feet, those dimensions equate to 48% rear yard coverage. At 15 feet, those dimensions equate to 32%. And then if he's at 16 feet, he would only be at 29% rear yard coverage and no variance is required.
Okay, and what is he requesting? How does he want to move it?
5 feet, 64% rear yard coverage.
No, what he just came back and asked for was something different.
He just asked for 5 or 10.
I'm just giving options. I was asking for 5 feet initially. I'm just giving options. I'm willing to go 10 feet or ask for 10 feet or whatever you guys will allow.
So his request is at 5, his request is 64%, which equates to a 5-foot setback.
Yes, that was the case we heard last time.
Right. So he can be anything greater than that, which his setback can be anything greater than that. That's not the request. His lot coverage can be anywhere between 30 and 64. We can grant him whatever lot coverage is less than 64. That just increases the setback. That's in our purview to do that.
And
Yes.
and if the board were to deny the variance,
Then
he could still build the building he wants with a 29% rear yard coverage. He just pushes them back to 16 feet.
Yes. So I'm just trying to find a happy medium here of what Mr. Thompson had requested when he started speaking was to not have to move the building 16 feet, but he wanted to move it less than that. And what was that request?
5 feet or 10 feet or 15 feet. He's given
Well,
a lot
5
of options.
feet is the current amount now, so 10 feet would still accomplish what he wants?
He can build that building without a variance.
I understand that totally. My inclination is to deny the variance.
Yeah.
But I'm hearing from my fellow board members that they're not necessarily in agreement. So I'm trying to find if there's something here, because I think something needs to be done here because that's what he agreed to when we had the continuance in the first place. Instead of coming back and now we're going to just grant the variance.
So at 16 feet, he doesn't need a variance.
Correct.
No.
And at
no.
5 feet, so if we split the baby, that's at 10, or roughly at 10 feet.
And that would
And
give
what's
him,
the- what's
what
the
would
lot
that,
coverage?
One second. That would be a 48% lot coverage.
Call it 50, just because we're kind of doing it on the fly.
Okay.
Would that work for you?
10 feet, okay.
I could support that. And I'm not trying to be argumentative. I've just historically said that, or gone on record as supporting if it's good one way and the impact's no different a different way.
I understand. My only opposition here is that I know that Mr. Thompson can build his building if he moves it without a variance.
I totally get that. I totally agree with that too. Member Ward?
That's where I'm struggling. That's why I kind of sat back a minute and listened, is what I'm hearing from the applicant is if we don't approve it, that he will go back and redesign. And I would like to see what he comes up with and if he really needs the variance. I hate to approve one that isn't really necessary.
I don't believe we're talking about a redesign. It's just.
Yeah, it's just moving a building.
Just moving it.
It's a prefab, correct? Pre-manufactured? Yeah.
But it can be moved with no reason for a
No
variance.
variance.
True.
So why are we approving a variance if it can be if it can be moved?
That's a good point as well.
Can I make a motion?
Absolutely.
Okay, I move we deny BA 250002.
We have a motion for denial of BA 250002 by member Clapp. Is there a second?
Second.
We have a second for the denial by member Ward. Rosalie?
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes.
Chairman, we have a motion for a denial by a vote of 3-0.
Right. The last item BA 250015 Urshan variance, District 1. Paula? Well, you gave us a presentation. Do we know, is Mr. Urshan, Rachel, were able to reach him?
Yes.
Paula?
Yes, Chairman Loper, members of the board, we do have them online. I just need to unmute them.
Okay. Could someone pull up the site plan or aerial for that? This is the one in Queen Creek. Oh, this is the landlocked lot. I call it that. Oh, and the undersized, but it's got a land use thing on it. R135, and it's less than half that size.
I'm sorry, Mr. Urshan, you need to unmute on your side. You need to enter a PIN number in order to unmute you. It said needs a PIN.
I imagine everybody needs a bathroom break. I'll try to keep this one quick. Mr. Urshan, I think Paul is trying to reach you via mobile.
Mr. Urshan, I have an audio pin number for you. There's a pound 23435 pound.
Chairman, this is David. I've sent Mr. Urshan the audio pin in his chat multiple times. If he can open the chat, he should be able to see those instructions. He has an audio device connected. It's just has to be authorized within the application. Alternatively, he could try to connect a cell phone. That'd be another method to get in.
I think Paul is trying to reach him. Is that correct, Paula? Or Darren, one of them are. I think in the meantime, we can open this up for discussion. I'll open the public hearing if we reach him. So we have before us two variance requests on a lot that's zoned R135, but it's a 16,336 square foot lot. It's less than half the size. The variance requests are half the size of what it should normally be. We got him on mobile, it sounds like. Okay. Mr. Urshan, we've gone over the background on your variance request. We are just asking you if you have a presentation that you would like to give us for your variance request.
Yeah, basically the lot is narrow and long. And with the setbacks on the front and rear, it would mean the house would have to be narrow and long, and that just wouldn't look right. That's the reason why I'm asking for the setbacks. And also it allows me room to move the house around so I can fit septic and a well.
Okay. Anything else you'd like to add?
That's pretty much it.
Okay. Any questions of the applicant by any of the board members? None at this time. Okay, just stay online for a moment. Again, variance request is for a 10-foot front setback and a 10-foot rear setback on a lot that is at 16,000 square feet in R135, where it should be 35,000 square feet. But the undersized lot's already been established through a land use application. So it's a little bit less than half what it should be. And the setback requests are about half of what they should be. The rear yard's a little bit less than half. I don't have an issue with it because otherwise we're looking at a lot that has no utility if the variances aren't granted, serves no purpose to the county or to the neighborhood to have it being vacant. The request is very reasonable in my mind. That's my 2 cents. We don't have a representative from District 1, it'd be Mr. Card normally, but I don't know if the board has any comments or questions or anything of staff or anyone, or is ready to take action. Member Ward?
I motion that we approve case BA 250015, enshrining the setback to wherever it might be. Oh dear. I move that we just approve it.
We have a motion for approval by Member Ward. Is there a second? Second by Member Clapp. All in favor? Oh, I'm sorry, Rosalie.
Member Clapp,
Yes.
Member Ward,
Yes.
Chairman Loper.
Yes,
Chairman, we have a motion for an approval by a vote of 3-0.
congratulations. Anything else? We're adjourned.
Thank you very much.
Thanks, sir.